In today's topic, we will be covering Lesson 4.2, Employer-Employer Relations, found in our business law textbook. The goals are to describe the terms of employment contracts and to explain the legal rights and duties involved in the employer-employee relationship, including termination of the employment contract. Employment is defined simply as a relationship in which the employer pays the employee to do work under the control and direction of the employer. The detailed terms of this relationship are found in the employment contract. Employment contracts typically involve written, oral, and implied terms. Like any other agreement, an employment contract must contain all of the essential elements of a contract in order to be enforceable. Terms such as compensation and fringe benefits are typically expressly agreed upon, as may be the job's duration, or the length of advance notice required in the event of termination. Implied terms, such as whether or not the worker should provide for his own safety gear, may be taken from the established practice on the job site. In addition, compliance with state and federal regulations pertaining to the employment situation, such as the withholding of Social Security taxes from an employee's pay, are treated as being implied by law. Typically, a failure to follow the express terms of an employment contract will be treated as a breach that will bring about the termination of the employer-employee contractual relationship. Duties of the employer. The employer has 3 duties to employees. These include the duty to compensate, the duty to specify a reasonable range of tasks, and the duty to provide a proper work environment. Compensation. The employer's primary duty to the employee is to compensate the employee for her or his productive efforts. This is done principally by paying a salary or wages. Compensation also can include fringe benefits, which are forms of payment not directly related to work performance. Fringe benefits may include pensions, vacation time, and health insurance. As long as the employee shows himself or herself ready, willing, and able to perform during the fixed period, the compensation is due, whether or not any work was performed. Unless they specify a definite term or require notice beforehand, many employment contracts are terminable at will. Either party can end such at-will relationships without notice at any time without involving the courts. Reasonable range of duties and treatment. The employer has a duty to the employee to properly specify a reasonable range of tasks to be completed. The employer also must treat the employee properly as he or she performs them. The employee cannot be required to perform acts outside the scope of the job as defined in the employment contract. Such requests would provide the employee with adequate legal grounds to justify termination of the employment relationship. However, quitting a job merely because the treatment is harsher than expected, or the tasks are more difficult, is not legally defensible. The employer is not permitted to subject the employee to unreasonably harsh treatment, such as assaults or batteries. For example, if the employer beats the employee can quit without any fear of liability for breach of contract. Proper work environment. An employee does not have control over the details of how the work is done. Therefore, the law maintains that she or he is entitled to a safe work environment. Unsafe working conditions provide the employee with another justification for ending the employment relationship without liability for breach of contract. Duties of the employee. Many of the employee's duties, such as obedience, loyalty, and reasonable care and skill, find their basis in agency law. However, the duty of providing production in return for compensation is at the heart of the exchange that exists in all employment relationships. This duty is not found in all agencies. Production. The primary duty of any employee is to produce a satisfactory work product. Work that is below standard in either quality or quantity can result in justifiable discharge of the employee. Obedience. Implicit in the employment relationship is the employee's agreement to submit to the detailed control and direction of the employer. This detailed oversight is what distinguishes the employment relationship from that involving the independent contractor or agent. The employee must obey the lawful orders and rules of the employer that fall within the scope of employment. Failing to do so provides grounds for dismissal. Loyalty. In return for compensation, the employer buys not only obedience, but an expectation of loyalty as well. Loyalty does not extend beyond the job, however. An employer may expect that its employee will not reveal confidential information or otherwise do harm to its business. However, the employer cannot demand that the employee use its products in his or her private life. Reasonable care and skill. By entering into an employment contract, the employee implies that she or he has the skills needed to perform the job properly and with the proper care. Termination of the employment contract. The general rule regarding termination of the employment relationship is that it can be ended at any time by any party to it for practically any reason. This is the at-will termination mentioned earlier. Such terminations do not ordinarily create a basis for a lawsuit, unless a contract or a collective bargaining agreement has set standards for dismissal. Exceptions to at-will termination. There are exceptions to the at-will rule. A few states require that firings be made as a result of good faith evaluations of the various factors involved in employment. Other states protect employees who are fired for refusing to violate the law, or for refusing to waive their rights under certain laws, such as workers' compensation. Most states, though, still follow the at-will perspective. The federal government has legislated exceptions in favor of whistleblowers. These are employees who alert the authorities to the misconduct of their employer. This applies even when the federal government is the employer. Non-compete clauses. Employers who must utilize secret information on product formulas or vital processes often have agreements not to compete, commonly called non-compete clauses, in their employment contracts. Such agreements limit the ability of a worker to enter into competition with his or her former employer for a reasonable period after termination of the employment relationship. If written too broadly, agreements of this kind counteract federal laws intended to spur competition. The courts will either void such agreements or reduce them to reasonable proportions. Generally, the legal effectiveness of such agreements extends to 2 years after leaving the employer and applies only within the market region of the ex-employer.